so pleased that you're able to join us today. This should be a fascinating discussion. For a few housekeeping matters before we begin, if for any reason you drop the meeting and you sign in using a different ID than the one you used originally, please email me at lori.nelson@law.utah.edu so I can make sure you get credit. You also have to stay in for the full 60 minutes pursuant to Utah Supreme Court rules to receive credit for the webinar. There will be time reserved at the end for questions. Please use the Q&A feature and not the chat feature, and we'll monitor those questions and get them answered. You ask, they answer. Anyway, thank you so much for joining us. It's my honor and privilege to be able to introduce our speakers to you, Christina Jepson and Michael O'Brien from Parsons Behle.
Well, welcome everyone. Thank you for joining us today. We're going to talk about the Great American DEI discussion, which a few years ago meant discussing how can we all improve diversity, equity, and inclusion in our workplaces, but it has changed it a bit. We are now discussing it in a very different way. It's more a debate about whether it should continue, and that's what we're going to talk about a little bit today. So just to jump in a little bit, first of all, our little legal disclaimer that this is not legal advice. And if you need actual legal counsel about any of these issues, please contact your legal counsel. All right, so DEI in recent years, just a little bit of background. DEI has been being implemented for quite a while, but really has increased over the last several years. I would say with the George Floyd murder, it even really ticked up after that, with a lot of companies, a lot of law firms initiating official DEI policies, procedures to try to increase diversity in the workplace. And as that happened over the last 10 years, there's also been an increasing number of attacks on those programs by those who think that they're harmful, who think they are reverse racism. And to just give you sort of an example of how maybe the dynamic has changed, let's just look at Governor Cox's change in attitude about this issue over the last few years. I think it's very emblematic of what's been going on. So if we look at Governor Cox from 2020 to 2022, he did a number of things that were very supportive of DEI. So for example, signing the Utah Compact on racial equity, diversity, and inclusion, doing proclamations on LGBTQ Pride Month, defending a Utah Jazz scholarship that was specifically for minority students, supporting diversity-specific curriculum in K through 12 schools in Utah, signing a number of bills that were supportive of DEI, including recognizing Juneteenth as a holiday, and vetoing a bill that was going to ban transgender athletes from high school sports. So he was really sort of on the DEI bus in a conservative Republican sort of way. He was supportive of DEI. And then everything really changed. So from 2023, his support has definitely waned. And so we've seen, for example, that he signed a bill limiting specifically discussion of race, sex, ageism, religion discrimination in K-12. And he has this quote, "There's good diversity and inclusion, and there's not good diversity and inclusion." And then probably, as most of us saw reported in the news just very recently, he said that DEI programs at Utah's colleges were divisive, and that if you have to sign a statement that you support diversity to be hired, that was awful and bordering on evil. After he made that statement, you may have noticed that a number of Utah schools, public colleges, and universities said that they don't have those statements, that nobody's required to sign a statement like that to be hired. And he responded with a number of job postings at some of the colleges, which asked applicants to write statements about diversity as part of their application. And this is a really interesting topic because we're going to see this more today. These statements about diversity are something that are used by a lot of organizations it's basically a way for organizations to get some input about people, about where they are on diversity. And there's been a lot of controversy about those. So we'll take a look at that a little bit more. One UVU job opening specifically asked applicants to include a statement outlining your plans for contributing to justice, equity, diversity, and inclusion. Very typical sort of statement that many organizations use in the DEI space, and very common in college applications as well. Then on January 5th, just a few days ago, the University of Utah sent an email to everyone at the school in charge of hiring saying, basically, in light of these statements, we're going to eliminate diversity questions or statements in higher education, and we'll stop having basically people fill out any statements about diversity. And as you also probably know, the Utah legislature, just like they did last year, is considering a number of anti-DEI bills that will be introduced in this legislative session. And we'll talk about a few of those later on. So that's kind of what's been going on with Governor Cox, as just an example. Here's a couple of, I guess, tweets from a couple of guys who like to fight about DEI. We have Elon Musk on the left, and then we have Mark Cuban on the right. Elon Musk is very anti-DEI with the I guess, clever little saying, DEI must die, DIE. And saying that the DEI is basically another type of racism or sexism that is morally wrong. And then Mark Cuban responding, basically saying, let me help you understand this. A number of people from historically excluded groups continue to be excluded in hiring. By extending our hiring search to include them, we can find people that are more qualified. The loss of DEI phobic companies is my gain. So he espouses the view that a lot of companies have, that we don't have quotas, but we are trying to increase our diversity by reaching out to communities who maybe have not historically applied for jobs, and try to increase the number of people who are applying for jobs, then choosing the best applicant, and hopefully in the end having a more diverse workplace. So that's just a little bit kind of about the controversy. I'm going to set up by kind of talking about the recent affirmative action case the Supreme Court decided with respect to college admissions. And then Mike is going to talk about what employers currently have to do in terms of complying with the law. I'm going to talk quite a bit about some things that are happening in terms of lawsuits in this area. And then Mike's going to talk about impact on DEI programs and some things that you can take away. All right, so I'll jump into the Supreme Court's decision, which I'm sure everybody heard about, SFFA versus Harvard and UNC. It's Students for Fair Admissions. And even though this is not directly related to employment in any way, you're going to see how this kind of set up a lot of the discussion that's going on. So a little more about the background here. The Supreme Court, for many, many, many years, well-established precedent, had said that colleges and universities could use race as a plus factor, not a quota. They couldn't have quotas, but they could use it as a plus factor in college admissions. So, for example, if they had a Black applicant, and they could consider that person's race as just one factor of many that was a plus factor. At the same time, of course, we've had companies adopting DEI policies where they're trying to get more underrepresented groups in their workplace. And then, like I mentioned earlier, we have these political groups, anti-affirmative action groups that have been attacking college admissions, have been attacking DEI, and have been attacking ESG, environmental, social, and governance policies, which are also really popular in the corporate world. So the Supreme Court just overruled that very long, well-established precedent that said that colleges could use race as a plus factor, and instead held that they could not, that would be unconstitutional or against the law. And many of these organizations that brought the SFFA lawsuit and attacked college admissions are also attacking DEI policies at private companies, and weirdly enough, attacking law firms in particular. And we'll talk a little bit about that. So in terms of the court's decision, there are really a couple of laws that come into play. First of all, there's the Equal Protection Clause, which we're all familiar with, the 14th Amendment that says there has to be equal protection under the law. So this would apply to state-run colleges, state-run institutions, not private colleges, but state-run ones. And that's what, under prior precedent, the Supreme Court had said race as a plus factor was okay under the 14th Amendment. The court now says that it's not. And then there's also Title VI. Title VI basically is very similar, saying that there can't be any sort of discrimination based on race, color, national origin if an institution gets any federal funds. So this is how private colleges get roped into this discussion. If they take any federal funds, like Harvard does, it takes federal funds, then they're subject to Title VI, and they're subject to this argument that using race as a plus factor could be discriminatory. So for many years, the court had applied strict scrutiny, which lawyers are familiar with, which basically requires that the state or the private institution put forth a compelling reason for wanting to use race as a plus factor. And they also had to show that it was narrowly tailored, that they were using it just as necessary to promote their goal of diversity. And under prior precedent, the court had said, yes, that test is met, that these colleges, private and public colleges, had a really compelling interest in advancing student body diversity, and that they could accomplish that by not having racial quotas, but by having it just basically as a plus factor. So under this plus factor procedure, basically you would have a holistic view of an applicant's file. You could consider race, but it couldn't be the deciding factor. It could just be one factor. So that was the narrowly tailored part. And that's really where we were for many, 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 many years. And then this organization, political activist group, led by Edward Blum, I think you say Bloom and not Blum, but we're going to see his name again. He's a big actor in this area. He started this organization called Students for Fair Admissions, and they sued Harvard, which is a private organization, so they would have sued under Title VI. And they sued University of North Carolina, which is a state-run organization, and so they sued them under the 14th Amendment. And when they sued them, they were suing them for something that had been held to be legal for many, many years. So what they were doing, these colleges were doing, had been considered completely legal and had been authorized by the courts before. But as we know, the Supreme Court recently has dramatically changed. We have a lot of new people on the court who are very conservative. And so this was Edward Blum's shot at seeing if he could get this long-standing precedent struck down. And he was successful, brought under the 14th Amendment and Title VI. So the court did, in fact, hold, I'm not going to go into great detail about the holding, but the court held that it was unconstitutional or violated Title VI to have race as a plus factor. The court had this weird little part at the end where it said nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. And that's basically those statements that we were talking about earlier, which Utah has just basically banned, or the University of Utah has withdrawn them in terms of using them for applications for jobs. So these are sort of having sort of statement where an applicant for a school or an applicant for a job can basically fill out a statement saying, this is something I want you to consider. And they can talk about race as part of their life history. So the court sort of left this open as that possibly this could still happen. But it still can't be a plus factor. So, kind of a head scratch about how that would exactly work. And Justice Sotomayor in her dissent saying, this is not going to work. This is putting lipstick on a pig, pretending like that's going to be a solution is just not workable. And we know that this is playing out right now in Utah. Okay, so we know that this decision, SFAA, has nothing specifically to do with employers. This is this decision is all about colleges and universities and their application process. Employers operate under a very different system, Title VII, which Mike is going to talk more about. So it's not directly applicable to employers at all, and yet it completely unleashed the current attacks on employers and their DEI programs and some other things they're doing as well. And so we're starting to see these lawsuits pouring in about and other challenges to private employers, which we'll get to later in the presentation. So that's basically the background on that. Now, Neil Gorsuch, specifically in his concurring opinion in support of the majority, said that there's no reason that Title VII, which applies to private employers, is any different from Title VI. So he was basically setting up this bullseye on DEI programs, and that's what we're seeing now. I wanted to point out sort of the real life consequences of the SFAA decision. And we know what the consequences are because about 25 years ago, California voters did the same thing. They passed an initiative in California to get rid of race-conscious plus factors in California schools. And when they did that, when they eliminated that, just to give you one example, enrollments at Berkeley and UCLA for Black and Hispanic students fell 40% immediately. So in terms of getting these historically disadvantaged groups in our college system so that they could succeed, it had an immediate impact. And schools reacted and have spent a couple decades trying to fix this situation. They've started de-emphasizing grades and test scores, having a more holistic application process, stepped up their recruitment in poorer communities, tried to do whatever they can to basically make up that ground. And they have made up that ground to a large degree, but it has taken many, many years, which I will expect the same thing will happen now that we have this federal decision not allowing race conscious, decision-making at all in the college process. So that's the background, and I'll turn it over to Mike to talk about the current legal framework for employers.
Thank you, Christina. Thank you in particular for underscoring the consequential nature of this particular issue. Of course, we like to think that as employment lawyers, everything that we do is consequential, but certainly some things are more consequential than others. I'd also like, as I start, to just make a shout out to Lori Nelson, who's retiring from the U Law School this year as alumni relations director. And Lori's a fantastic, wonderful person. You may be sad about some of the football players who aren't coming back for the U next year, but you're especially sad that Lori's going on to other adventures. And then I have to mention Christina Jepson, my friend and colleague, who is the 2023 Utah Employment Lawyer of the Year. Congratulations, Christina, for that well-deserved award. Always a pleasure to work with you. She's also demonstrating some pretty great skills in screen sharing today. And so I apologize for my occasional request to her to move the slides ahead, but she is handling that task for us today and doing a great job. So Christina, would you please move ahead one slide? As Christina mentioned, Title VII is what regulates the employment world when it comes to DEI type issues. Title VII of the Civil Rights Act of 1964, which probably most of you are familiar with, certainly employment lawyers are, as are HR professionals. It protects employees and job applicants from discrimination based on certain protected classes, including race, color, religion, sex, national origin, and other protected classes. Although Title VI and Title VII have similar language, it's important to note that affirmative action in those contexts is distinct from what the education context does. And we in the employment world are governed by different rules and by different case law. So we want to talk a little bit about that for a few moments, so we have that context properly in our heads as we go forward and talk about where things are going these days in DEI and what we still can do and what we probably shouldn't be doing. So again, we've got it in red and yellow highlight in all caps and bold, just in case you miss the emphatic nature of our point. With very few exceptions, an employer cannot consider race or other protected characteristics when making decisions. Christina, maybe we should have put an exclamation point at the end of that sentence just for emphasis. But again, that is the rule and the law in employment law. It was the rule before the Supreme Court case that Christina talked about, and it remains the rule afterwards. And that must be what employees do to govern themselves in this area. Next slide, if you would, please, Christina. There are, of course, a couple of exceptions where affirmative action can be taken under Title VII by employers. And when Christina's talking again, maybe she can address this point too, but I've been doing employment law for almost 40 years, and I've never had a client call me to ask me to do any of the affirmative action programs that I'm going to talk about here briefly for the next few moments. So that, I think, is proof as to how rarely it happens in the employment world. But in a case called United Steelworkers of America versus Weber, the Supreme Court held that an employer can adopt an affirmative action plan to favor a protected class, but only in limited circumstances. So there had to be a purpose initially of eliminating what's known as a manifest imbalance. Now, those are pretty strong words from the court, right? A manifest imbalance, not just an imbalance, a manifest imbalance, which is demonstrated by statistics. The plan to resolve that manifest imbalance would have to be narrowly tailored and not, open quote, trammel the rights of other workers by requiring their discharge or blocking their advancement. And then, of course, the plan had to be temporary as well and limited to the time it takes to achieve a balanced workforce and eliminate that manifest imbalance. So that's a very narrow window where sort of a race plus consideration could occur in the employment world. And that was codified in the EEOC regulations. If you'd move ahead one, please, Christina. There are regulations under the EEOC CFR provisions that allow employers to do voluntary and affirmative action in similar circumstances for women or minorities. And again, we've highlighted some of the key issues that show the limits of it. Again, this is a program I've never been asked to help a client implement. But there have to be facts showing an actual or potential adverse impact from existing or future practices. There has to be a need for correction of that by some sort of affirmative action in the race plus sense. And it has to be because of historic restrictions by employers, that because of historic restrictions by employers, the available pool, particularly of qualified minorities and women, is artificially limited. So again, some rather unique circumstances under which affirmative action could be taken in that sort of race plus sense. Next slide, please. Similar to the Supreme Court case I mentioned, the Weber case, to implement an affirmative action plan of that nature, an employer would have to do a reasonable self-analysis that would in effect show the equivalent of a manifest imbalance. There had to be a reasonable basis for engaging in the sort of affirmative action that has race plus consideration. And the action itself would have to be reasonable, meaning I think that it would have to be temporary in nature and short-term, much like the Weber case outlined. So there's another phrase in the employment world involving affirmative action. Next slide, if you would, please, Christina. That refers to, I'm sorry. I'm going to say again, it's rare, right? I've said that 3 times already, so we'll say it in blue again. Those sort of race plus characteristic affirmative action plans are rare and only under unique circumstances. But what's not so rare is what is reflected on the next slide, if you would, please, Christina, which is if you're a federal contractor, there's something called affirmative action for you too. It's a very different kind of affirmative action. It's in fact, it's probably a misnomer. Probably a better phrase would be affirmative recruiting or affirmative analysis. Asking employers to take a look at their workforce in comparison to the available workers in the area and see if they can achieve a balance between the available workers and what the actual workforce in the area looks like. And this is administered by an office called the OFCCP, the Office of Federal Contractor Compliance Programs. And again, as Christina mentioned, it is very different than the affirmative action that she was talking about. It's not race plus considerations. It's not considerations of race in decision-making at all. Instead, its emphasis is that it's trying to get employers to engage in employment activities without regard to individual race. So how might they do that? Next slide, please. Well, they require, the OFCCP regulations require affirmatives to engage and develop and maintain what are known as affirmative action plans. And if Christina, like me, probably has helped clients with several of these. But essentially, these are very different than the sort of affirmative action you saw the universities engaging in. What these are plans where an employer will analyze its workforce to determine whether or not it is short in terms of the number of employees in various protected classes as compared to the workforce that exists in the area. So it requires a workforce analysis in terms of various job positions and what people in what protected classes are in those jobs, and a comparison of that to the local community. So for example, maybe you have, 0 Irish Catholic lawyers in your organization, but you find that there are, in fact, 15 or 16 Irish Catholic lawyers in the community who are ready, willing, and able to do the work for you. And you decide we are underrepresented in Irish Catholic lawyers. So it doesn't mean we're going to get rid of the non-Irish Catholic lawyers to bring in the Irish Catholic lawyers. No, instead, we're going to develop a plan where we're going to try to recruit those Irish Catholic lawyers. We're going to encourage them to apply for positions for which they're qualified. And we're going to do things to increase our applicant pool so that maybe we're getting a better look at the available qualified candidates before we make our hiring decisions. So that's what that sort of affirmative action is about. And again, using color to emphasize what this really means is a federal contractor cannot set quotas or set aside certain jobs based on protected classes. So it's simply not what the universities were doing. Next slide, if you would, please, Christina. Again, as I mentioned, it's a wholly distinct concept of affirmative action, right? It's more like affirmative effort. It's more like affirmative intent, right? It's raising consciousness about, are there workers out there that you're simply not considering for one reason or another who are qualified and can add value to your organization? And is there a way to bring them into your scope so you can possibly see that there are people with diverse backgrounds who can add to the success of the mission of your organization? That's really my own take on what affirmative action is about for federal contractors. Next slide, please. So again, you see that what really impacted employers in many ways, because I got a lot of calls from employers after the Supreme Court decision, as did Christina, I'm sure, saying, okay, what do I do now about my DEI initiatives? And, what we would do is basically remind them what Title VII requires and make sure they're complying with that law and not making decisions based on race. And then from there, help them make sure that that sort of analysis continues throughout the course of the implementation of their DEI plan. So it's the same as it was before, but it hasn't always been treated as if it was the same as it was before. And there's been a lot of heat generated about employer actions in this field. And Christina's got a really interesting set of examples to present to you on that. Christina, take it, please.
Yeah, so I'm going to talk about the heat. Oh, by the way, did you all know that the reason Mike O'Brien works at our firm is because we did not have any Irish Catholic attorneys, and he was hired as a part of an affirmative action plan to get more. So actually, we're just so happy to have one of the best employment attorneys in Utah. So I'm going to talk a little bit about some of the stuff that's happened in employment law since the SFFA decision. It's pretty interesting. So right after the decision, the EEOC, which Equal Employment Opportunity Commission, which changes from presidential administration to administration, its composition changes. But right after that decision, the EEOC chair, Charlotte Burrows, who's a Biden appointee, and I normally wouldn't say she's a Biden appointee, who cares, but you're going to see that this becomes quite political. So she issues a press release after that decision about school admissions, saying this does not address employer efforts to foster diverse and inclusive workforces. It remains lawful, basically, to have DEI programs. And anyone who wasn't paying close attention to this area and saw this might think, well, why is she saying that? That decision was about college admissions. And it's because everybody knew that the next thing in the bullseye for the groups that brought those lawsuits was to go after DEI programs. So she comes out and says, this doesn't affect DEI, right? And then right after that, Jocelyn Samuels, who's the vice chair of the EOC, also a Biden appointee, basically does an opinion piece saying kind of the same thing, that DEI is legally distinguishable. It's different from what they decided in SFFA. And so, or I'm going to call it the Harvard decision because it's hard to say SFFA. But basically that they were legally distinguishable. Again, trying to say, everybody calm down, DEI is fine. But then we have another EEOC commissioner, Andrea Lucas, who is a Trump appointee. And I've heard her speak on this topic a lot. She's very interested in DEI. And she basically kind of said the opposite. She said, you need to look closely at your DEI programs, that in light of this decision, this Harvard decision, employers need to consider whether their DEI programs are legal and have not gone too far. And one thing this wasn't in her statement, but when I've heard her speak, one thing she says in particular is she thinks that employer affinity groups, so say you have a women's employee group, a women lawyer group or something like that, that those affinity groups, in her opinion, need to be open to everyone or they're discriminatory, potentially discriminatory. So she kind of has a strong opinion in the opposite direction. So then just to kind of jump on and add more, right after that, we had Republican AGs from 13 states who sent a joint letter to the Fortune 100 CEOs. I'm sure they were glad to receive it. A letter basically telling them that they needed to be careful of DEI programs and that the Supreme Court's decision should place every employer and contractor on notice of the illegality of racial quotas, which you could never have, and race-based preferences in employment and contracting practices, which you could never have. And then right after that, to respond, of course, you had 21 Democratic AGs also write a letter to the Fortune 100 CEOs saying kind of the opposite, that the letter from the Republicans was basically an attempt to intimidate them into rolling back the progress that they've made, and that they should have, having aspirational diversity goals and concerted recruitment efforts to improve diversity are fine. Now, really, they're saying two opposite things here that are both true, but they're trying to, I guess, have opposite reactions. The Republican AGs said you can't have racial quotas. That's true. Employers cannot have racial quotas. They can't have race-based preferences. And the Democratic AG said you can have aspirational diversity goals. You can have a goal to have more women in management, for example. You can have more concerted recruitment of women and other minorities. So both of those things are true, but not agreement about how DEI should be viewed. So then we, right after that, have Senator Tom Cotton. He sends a letter to 51 law firms. I don't know why he chose law firms. We didn't get one, so I guess that's good. That means we're not the top 51 law firms. And he tells them, he cites the decision, the Harvard decision, and says Congress will increasingly use its oversight powers, and private individuals and organizations will increasingly use the court. Both of those things have turned out to be true, to scrutinize the proliferation of race-based practices to the extent that your firm continues to advise clients regarding DEI programs, or if you have one on your own, preserve relevant documents. So for all the lawyers out there, what do we call this? Preserve the relevant documents. Mike, you're the only one who gets to answer.
Litigation holds.
Yeah, so weirdly enough, a senator sent a litigation hold letter to 51 law firms. Not sure he could really do that, but anyway, he did. So we have that. And then after that, we start seeing a number of lawsuits and other actions being brought mostly by anti-affirmative action groups or employees or former employees. And you'll see some shareholder lawsuits as well, attacking different elements of DEI programs. One of the ones you probably have heard about, remember Edward Bloom? He's the one who was the force behind the Harvard decision. He founded another group called American Alliance for Equal Rights to sue law firms and other employers. So they immediately sued 3 law firms who happened to have internships that favored groups that have been historically disadvantaged. So Morrison Foerster, Perkins Coie, Winston Strawn. And he alleged that the diversity fellowships or internships for summer associates, because they favored underrepresented communities, violated Title VII. And, they probably did. I think there are many people who think it's perfectly appropriate to set in a law firm dominated by white men, to set aside an internship to advantage groups that have been disadvantaged, but they are probably technically in violation of the law. So all of those lawsuits were eventually dropped after the firms changed the language of their fellowships. They all changed the language to make them open to everyone. The Bloom Group is considering more suits, has sent warning letters to more law firms. Some of the warning letters have been successful in getting law firms to change their policies with respect to those internships. So the internships that were attacked, just so you know, they all had language that basically said, these are for historically underrepresented groups. And because they at least suggested that the people who could apply and get this, it was a job, even though they're internships, they're a job. So it's employment. They can't be limited to just certain groups. So they all changed that language, to different language. People who bring a diverse perspective to a firm, people who go to accredited law school, just eliminating the criteria altogether, those sort of things. And those lawsuits went away. Another group called Do No Harm sued Pfizer. So this isn't a law firm. Saying that their fellowship that they had, that was basically a fellowship to improve the pipeline for Black, African American, Latino, Hispanic, and Native Americans, they sued there, and Pfizer ended up changing their criteria to say that you could apply for this regardless of your background. And then we have America First Legal, which is an organization that was created by Stephen Miller, who should sound familiar. He was a Trump advisor. His group brought a lawsuit against the independent commercial producers. They had an apprenticeship program that set aside a single position to basically, again, help Black, Indigenous, people of color. And the way they sort of got standing in this lawsuit is they found an employee who was a white male who claimed he had been denied work opportunities because of this apprenticeship program. These groups have also been bringing a lot of EEOC complaints, so complaints with the Equal Employment Opportunity Commission. There have been over 24 companies that have been targeted with these complaints, which America First Legal calls woke corporations. Basically, these, everyone's a little bit different, obviously, but the complaints basically allege that the DEI policies that those organizations have in some way are unfair or some way harming people who are not targeted to benefit from those programs. The EOC, so far, to my knowledge, has not opened investigations or filed charges related to the actions. They're probably still in process. As Mike and I know, the EOC does not act particularly quickly. So no surprise there. I'm not sure that it means anything. They're a little bit backlogged. So we have that. We also are seeing a number of shareholder lawsuits. So these are shareholders of corporations who have been bringing lawsuits to say that in some way DEI programs are harming them as shareholders. And they have sent these public shareholder letters, which have caused some companies to change their initiatives. And we see that Stephen Miller Group again sending a lot of these letters to corporations, on behalf of shareholders or threatening shareholder suits. So this caused JP Morgan to change one of their programs. BlackRock changed a scholarship. I'm not sure how you say this company, Contour Brands, Lee Jeans, also were targeted, a number of different companies. So one that we'll all be familiar with, of course, Starbucks, their directors were sued by a conservative shareholder group. And they alleged that Starbucks directors were pushing DEI initiatives to get credit, basically at the expense of the company. The case was dismissed by the court, saying that basically courts have no business involving themselves in legal decisions by board of directors. Those of you who work in corporate law know that there's a lot of discretion the board of directors have to make decisions for their companies. That's not my area of expertise, but that's what I remember from law school. So many of those have been unsuccessful. Some are just filed, so don't know where those are really headed. Another shareholder lawsuit against Target, attacking their DEI program and their ESG. In case you're not familiar, ESG, if I remember right, is environmental, social, and governance. It's very big internationally, companies trying to be more environmentally appropriate, socially appropriate, having, ethical governance, that sort of thing. There was also a shareholder who sued Disney's director because Disney, of course, had opposed the Don't Say Gay bill in Florida. And again, the court, didn't have any sympathy for the plaintiff in that case, meaning that, corporations have a lot of ability to do what they want to do in that regard. I'll mention one lawsuit that's sort of on the other side of the spectrum. This brought by some people on the left. After the Harvard decision, there has been a lawsuit by some students saying that legacy admissions, basically legacy admissions are those admissions that favor people whose parents or grandparents went to Harvard. And if your parent or grandparent or great-grandparent went to Harvard, you're way more likely to be a white individual. And so this lawsuit says that basically legacy admissions are preferential treatment to wealthy donors and legacy students, and that those are violative of the law. So that's new lawsuit. Don't know where that one's going to end up either. A couple other things, not directly related to employment, but just starting on January 21st, this law will go into effect, Texas Senate Bill 17, which basically outlaws at any Texas public universities DEI offices and prohibits anyone from working for a DEI office, prohibits people making DEI statements in hiring. So remember back to what the University of Utah just recently did in response to what Governor Cox said, which is to try basically eliminate DEI statements from hiring processes. That in Texas has been codified into law. And you also cannot, sorry about that typo, participle. You can't require as a condition of enrollment or employment that a person that should be participate in DEI training. So basically eliminating DEI training from Texas public universities. University of Houston has tried to say that this doesn't affect the academic side, that in terms of academics, professors can still talk about DEI, can teach DEI, can research in that area, but we'll see how all of that plays out. On January 8th, the Salt Lake Tribune reported that there are 3 bills being considered by the 2024 legislature. One of them would require DEI offices at colleges and universities to change their focus to first-generation students and students living below the poverty line instead of focusing on gender or race groups. One is a bill banning colleges from asking applicants anything about inclusion or diversity. And another one would ban all employers, including private employers, from having any kind of requirement that employees sign anything agreeing to any beliefs on diversity and inclusion. So I have no idea what's going to happen with those bills. Those are just being proposed. Most of those bills last year were unsuccessful. So we'll see what happens this time around. Lots going on. Now, But one really interesting thing that's been going on that is easy to miss, and that if you're an employment lawyer, you know that you can't, you could only bring a lawsuit for discrimination if you can show that there was an adverse employment action. And an adverse employment action usually has to be something pretty serious, like not getting hired or getting fired or getting demoted, having a change of pay. And in this case, in Muldrow, the female police officer, none of those things happened to her. She was just moved to a different area, but she had the same pay. So under sort of traditional law, she could not show that there was an adverse employment action. And she was trying to say that that should be considered an adverse employment action. And interestingly, usually people who are more on the left, more plaintiff oriented, would be in favor of this sort of move in the law, would want more things be considered an adverse employment action. And people who are maybe more employer oriented or more conservative would say, no, we need to limit this to really serious adverse employment actions. But the really weird twist in this area is that some people who are anti-DEI want to see the concept of adverse employment action broadened so that people who think that they have suffered because of DEI programs can bring lawsuits. And this Melissa Murray from NYU has pointed out some questions from some of the justices, conservative justices, which she thinks indicate that they could adopt potentially this concept of a broader definition of adverse employment action with keeping in mind that, attacks on DEI would be benefited, I suppose, from that. So a lot going on, and that was just a little bit. There are more things than that. I just a sort of a little thumbnail of a few things that are going on out there. And now Mike will talk about DEI programs.
Well, lots of heat, Christina. We could have done, I think, a full hour on that alone. I know as you and I have prepared this, along with our colleague Aaron Murnaka, by the way, who's been helpful to us, very, very helpful to us. You had to weed out a lot of the heat just to sort of get to the hottest of the heat. But what do we lawyers do, right? We help our clients deal with the heat and figure out how to manage the risk that comes with the heat. And that's what we wanted to end on today. So we wanted to give you a little bit of a sense of the takeaways and the impact of, of all of this, what you can and can't do. So if you jump ahead one slide, please, Christina. A UNLV professor had a really interesting thought on this that our researcher, Aaron Murnaka, dug up. And she said it's a very odd place to be in corporate America and trying to do something that you think is the right thing, and yet being worried about whether that's legal or not. So, obviously corporate America does need to think about whether something is legal or not before they do it. But it just, I think, was a very, very insightful comment about some of the struggles that are going on in that world. Interestingly enough, we didn't get this on our slides, but I think it was yesterday, one of the updates that Christina and I received included an article that said 70% of employers who were surveyed are still planning to move forward with DEI programs in one form or the other. Hopefully, they're getting the great counsel that you all are getting today about what they can and cannot do. Because ultimately, next slide, please. The decision of whether or not to move forward with a DEI program is a cost-benefit question, right? What are the costs of doing so? What are the benefits of doing so? And I think given all the heat that Christina has outlined, a lot of employers right now are taking a careful look at this cost-benefit analysis. And as I do that, we have some tips for them, and that's on the next slide, if you would, please, Christina. Obviously, they need to review the policies to ensure they align with the company and its leadership values. They need to make sure that they align with company commitments that are achievable. They need to look at the data that's collected as part of all of this so that it's a data-driven project as opposed to sort of an effort to fix problems that either aren't there or to fix different problems than the ones that are there. Of course, the fourth bullet point is critical, right? The decision makers have to be trained on the policies and what is or is not permissible when they're making employment decisions. And then we need to get everybody on the same page, leadership, HR, legal compliance, regarding what the company is going to do and how it's going to do it. Next slide, please. When you're doing that legal review, again, some thoughts and takeaways. You got to comply with current law, right? I mean, easy to say, right? You would think it would be obvious and clear, but as Christina pointed out, some of our fellow law firms, perhaps well-intentioned, nonetheless stepped in it, right? That's a technical legal term, by the way, stepping in it, and they drafted programs that, from at the very least a technical standpoint, created violations of the law. To their credit, they fixed it when it was called out to them. But it's important to recognize that the concerns raised by the Republican attorneys general and the Senator Tom Cotton letter were all asking companies to do things that many companies already are doing. In fact, most companies are already doing, who have good employment lawyers, which is not engage in the use of quotas or race-conscious employment decisions. By the way, I was intrigued that there were some like 20 Democratic AGs and 13 Republican AGs. That leaves like about 13 or 14 or 15 AGs who just didn't weigh in whatsoever. And I'd love to know what they were thinking. Maybe they didn't want to get involved in the heat, right? Anyway, the last bullet point on this, when you're doing a legal review, is you have to make sure that you're looking at this in the context beyond race and beyond gender. And Enterprise Rental Cars is a good example. They were sued recently by the EEOC for age discrimination based on its recruitment of management trainees on college campuses, right? As if old dogs like me, might not be interested in an enterprise management training program. So again, this has more moving parts to it than just the race and the gender issues that we often think about when we're dealing with it. Next slide, please, Christina. Here's a nice slide where we tried to sort of tell you what you can and can't do in one slide. And I was told once not to put more than 8 words on a PowerPoint slide, and so I apologize that we violated that rule here. But the permissible actions are, you can still do DEI training, training on implicit bias or diversity issues, as long as you're compliant with state law, because some states, in particular states that are down south and grow a lot of oranges and have cities called Miami in them, have made rules about this sort of training. You can create a structured interview process to ensure that candidates of diverse backgrounds are evaluated in an equal way, right? Asking everybody the same questions, making sure they're scored in the same way, making sure those questions are really relevant to the job. Targeted recruiting that focuses on certain populations to ensure a diverse candidate pool. If it's part of a larger recruitment effort, it's still legal. It was legal before, it remains legal today. Creation of non-discriminatory training programs to address a lack of qualified applicants. Support of individuals in underserved communities once they're hired. Christina mentioned the affinity groups, which many employers often set up. We have a great Irish Catholic lawyer affinity group here at Parsons. It attracts a lot of people because we serve whiskey on occasion. But seriously, on a more serious note, I've seen groups like older worker groups created by employers that focus, again, on the wide range of diversity in the workplace. And then, certainly meeting employees where they are, offering remote work or flexible hours or those types of things that maybe in particular would be helpful to groups in underserved communities, all permissible actions. But what you can't do on the right side of the slide is create jobs or job openings that are only open to specific genders or races or ages. Same is true for training or internship programs, as Enterprise is finding out. And you can't fire or refuse to hire or promote white or male employees in favor of minorities or women. You can't hire or fire to maintain a racial balance in the workforce. And numerical quotas, as we've said over and over again, perhaps we haven't said it enough, but we've tried. Numerical quotas are illegal under the law. Next slide, please. So future legal developments, right? As Christina indicated so eloquently, this is a really dynamic and rapidly evolving area of the law. So those of you who are lawyers advising clients, you're going to have to stay up to speed on it. Those of you who are HR professionals, because we get some of them in these programs, you're going to want to make sure that you're staying up to speed and have good employment counsel on speed dial. Companies have to monitor the developments carefully because there's always the potential for rapid change, especially during the legislative seasons. Not coincidentally, Parsons publishes a bi-monthly newsletter on employment law. It's free, right? It's free. And we talk about DEI issues frequently in it. If you'd like to be part of that group that receives that newsletter, please contact one of us. Our emails are going to be at the end of the presentation. Next slide, please. So the takeaways, right? Nothing has changed in employment law as a result of the Harvard case, at least for now. If your DEI policy was legally compliant before the decision, it still is legally compliant. But the likelihood of challenges to DEI is increasing, again, as Christina's presentation demonstrates. The likelihood of a Supreme Court ruling adverse to DEI, I think we've got to say that that's probably increasing as well, given the court's changing makeup, given some of the signals we got on the Harvard case. We don't have a DEI case that's been decided by the Supreme Court yet, so that's speculation, but it's reasonable to speculate that change might occur at that level too. Now's a good time to evaluate your policies, make sure they're legally compliant, and again, as we've mentioned, keep monitoring it in the future. Next slide, please. Thank you. Next slide, please. Here's our email addresses, and again, to shout out to Aaron Muranaka, our research manager, for his great assistance in preparing this presentation. Lori, we'll throw it back to you.
Thank you both very much. We have a question. For federal contractor OFCCP compliance, is it even possible to get rid of a DEI team? Could you just call it another name if you're worried about the heat?
Yeah, right. I mean, that's, yeah, what is it, Shakespeare that said a rose by any other name is still a rose, right? But if you can still have the benefits of the rose by calling it something else, then that's, I think, an interesting strategy to look into.
So, Christina, I think it was you that said at the beginning of the program that for years, quite a long time, there has been a focus on a more holistic approach to applications for education and some employment jobs. Do you think that is going to go away, or do you think that holistic approach will continue?
I think the holistic approach is actually going to increase, but it's going to be a little different. So before the Harvard decision, there was a holistic approach to applications that included race as it could be a positive plus factor. Now you can have a holistic approach, but you cannot have race as a positive plus factor, but you can look holistically at a person's application, including, do they come from a disadvantaged background? Do they come from poverty? Are they a first-generation college student? And many of these things apply as well to employment. Really the goal here being that we all look beyond the normal people we would hire, right? So use an extreme example. If I had a job opening at my law firm and I only sent it out to my sorority sisters. I wasn't a sorority sister, but if I were, I've only sent it out to my sorority sisters, I'm only going to get one kind of applicant, right? But if I make sure that that is sent out to a lot of different groups and a lot of other different people in the community know about that job, and that when they apply, I treat them equally and give everyone a fair shot, then we're going to get a very different sort of pool of applicants and different employees in the end. And that's the goal, is to just treat people equally and fair.
Well, we're out of time. Thank you both so much for presenting today. Mike, thank you for your kind words. I am retiring, but I will still do some CLE through the end of February.
We'll miss you, Lori. You're the best.
We'll miss you, Lori.
Thank you. This job was a great job because of my alumni, and you guys are shining examples of the best of the best. Oh, I lied. Oh, no, that wasn't a question. Thank you very much to all of you that participated today, and I hope to see you at a future CLE. We will have more in February and ongoing after that.